going to say bottom line is to hold on to your intellectual property rights and license people the opportunity to do something with it, but don't assign those rights. Don't give up the ownership. You can always find a way to let other parties do whatever they want to do with your code, etc., without actually giving up the code. And I have an example. Actually, it occurred with a Dutch publisher, in which a Russian company had signed a contract, and here's a couple of excerpts from the contract with the Dutch publisher, and given the Dutch publisher an assignment of the source code in the game. And the Dutch publisher never actually paid a nickel at all, whatever they, guilder or euro, never paid anything for the game. And so the Russian developer said, okay, you didn't pay me, so I'm going to take the IP back and publish it and sell it elsewhere. And the Dutch court said no. And that case has been going on for a couple of years, and the Dutch court said, no, you assigned the IP, they own the IP, so if they didn't pay you for it, you have to sue them for what they owe you. And in fact, they've actually gone out and sold the game and been selling the game and not paying royalties. So it's very important to think in terms of what law is going to govern the dispute between parties, and I often recommend using international arbitration of some type. That's a very inexpensive way to resolve international disputes, and what I suggest is you agree on an arbitration provision, and you also put something in there that says that witnesses who reside outside of the jurisdiction where the arbitration tribunal sits can testify telephonically, because if you do find yourself and you're in a dispute and you have to go to Los Angeles, that's an expensive trip and takes a lot of time.
What would be the case if it would be American law or international arbitration? Still the same?
You can specify the type of law. So there are you can say it's going to be United States law that applies, but the arbitration will be in London. Or you can say it'll be Swedish law that applies, but the arbitration would be in Moscow.
Still the question, for this, if you do the assignment and then don't have any payment, will you still have a chance to get your rights back?
Yes, yes. In the United States, you would have a very good case to get your rights back, because there'd be a lack of consideration. And also, I mean, I didn't do the contract in this case. I only asked to look at it after the problem arose. But in your contract, you always want to think about what happens if you end up dealing with a branch. Those of us who've been in this business for a long time, we can tell you 10 other publishers that used to be here that had their $500 million in the bank and that went out of business and left a lot of people unpaid. And there's some of them that are still hanging on. So you really need to make sure in your contract that you specify what happens if you don't get paid. And that you have a means to get into some court or some arbitration tribunal quickly and get your property back. I mentioned a little bit the sample royalty reports. I'm going to just touch on that very briefly. It's amazing to me how many times people sign contracts, and by the way, I understand that lawyers are expensive, and so many times people want to do their own contracts, and then they have problems, and that's when they come to lawyers, and that's fine. But I'm often in a situation where I'm scratching my head and I'm trying to figure out, what does this net sales definition mean? And I ask the client, what did they think when they signed the contract? And they're like, I don't know. So I've kind of just taken in my own way to attaching a sample royalty report. So here's a sample, net sales on sell-through. In this case, the client is a Scandinavian publisher using a U.S. distributor to distribute their product in the United States. And this is just sort of a definition of how you get to net sales and what you get paid on sell-through. And so we just attach a very simple little sell-through royalty calculation on the back, and as an exhibit to the contract, which, if you do end up in a dispute over what royalties are owed, and that happens, and especially happens when people don't have the kind of relationships that Alex was talking about. Well, you've got something here that makes it clear, and believe me, even if you understand it, the judge who looks at this, who's never played a video game or has some vague awareness of what video games are and the entertainment industry is, they're going to have no idea how to figure out who's really entitled to what when it comes to net sales. And this kind of a calculation that you can all do and attach to your contracts will make it possible to go to a court or go to an arbitrator and get the kind of relief you want. One more thing is records retention. Okay, I've had several cases with one particular Russian developer and publisher who's been in disputes with different distributors and publishers in the United States who've rejected some of the products that were submitted. And I've had some lawsuits that have gone to trial in the United States, not for this particular claim, but for others. And in one case we had we spent hundreds of thousands of dollars, and I was representing the developer, and they ran up the bill anyway. Luckily, we won the case and we got paid. But the issue was whether the publisher had been correct in rejecting the beta milestone in that case. In the case of this particular Russian publisher developer that I'm talking about, when they had several different games that had been rejected and milestones that had been rejected, and I said, okay, let me see the build so that I can have an expert look at it to testify as to whether it meets the standard in the contract or not. And this particular individual said, well, I don't have it, we didn't keep it, and I said, well, do you have any correspondence as to what happened when you submitted it? And what the response was, no, we deleted all the emails. So, I would have thought it's obvious, but it's not obvious. And here's an example, and I just want to say that well after the game is released, this can come up. I have one really terrific client in the world who has developed a number of great games, and developed a game that was released in 2008. And the contract had a provision at the end that said that after the game is released, all of the archives had to be turned over to the publisher and to the licensor, because it was a game that was based on a licensed property. And at the time the game was finished, my client said, to the person he was working with on the other side of the development process, do you want all the archives? And they said, nah, we probably don't need it. We'll let you know if we need it or something like that. So, my client, basically flushed everything one way or another. And 2 years later, the licensor decided to do a sequel and to do it with a different developer, and went back and looked at the contract and realized that they had the right to all of the art assets that had been developed by my client for the game that my client did for them. So this is an actual letter, shortened up a little bit, that I got from the head of legal at one of the biggest publishers in the world 2 years after the game was out, saying we're entitled to all these assets, and I said, well, it's too late. We don't have the term, the contract's over, etc. Well, their position is that we have to reconstitute them, which of course means taking the team off another game that they're on and putting them on that now. I don't think they're going to push that. I don't think they're going to prevail if they do. But it caused me to sit down with my client, and we talked about when you finish a project, putting together an archive, putting something on a hard drive, sticking it someplace in a refrigerator, so that if and when these problems show up, you've got it.